Madam Speaker, these 6 individuals have gone through a self-disclosure process. So they've gone through a self-disclosure process in relation to, or my understanding is in relation to CCDSL, and I would expect that the same would be the case in relation to Lifecome. I don't know this, but given that I have been informed that this was the case with CCDSL, I would assume that it's the case before. So there are risk assessments that are put in place in order to assist these individuals, because many of these relate to expired offences, Madam Speaker.
I fail to understand how this wasn't picked up before, if they are indeed individuals that went through the 2P transfer process.
We are certainly a government that believes in rehabilitation of people, and we don't believe in holding people for the rest of their lives for an offence which has expired. So the individuals involved went through a self-disclosure to CCDSL of their previous offences. Most of these offences have already expired. Most of these offences were explained to CCDSL, and CCDSL, and I imagine prior to that Lifecome, have put in place a risk assessment and appropriately managed these situations so that they are confident that they are not sending these individuals to users.
Are there cases where some of the offences were not spent offences or not expired? Is that the case?
The issues arise when there is no self-disclosure, when a certificado penal is provided incorrectly, or when a certificado penal is provided inaccurately. So in those instances, of which we do not have evidence of any yet, in those instances, there would be an issue. But in the instances that an individual has come forward and made the appropriate self-disclosure, the view can be taken by CCDSL, indeed working with the appropriate agency, which is the very agency that is contracting them, the care agency, in order to work through some of these instances.